The most common type of restructuring procedure in Poland is the procedure to approve an arrangement. Jakub Kokowski, advocate and restructuring advisor, senior associate at Wardyński & Partners Bankruptcy and Restructuring Practice, who provides comprehensive advice to businesses on restructuring and bankruptcy, as well as on the acquisition of distressed assets, will tell you about it. Later, we'll hear an update on the Polish economy.
Entrepreneurs who are struggling financially may avoid bankruptcy by restructuring their debt. This may be achieved through one of 4 restructuring procedures provided for by Polish law. The most popular is the approval of an arrangement, which enables an effective arrangement to be entered into with creditors in a relatively short time and with limited court involvement. The procedure for approving an arrangement is distinguished from other restructuring procedures by the fact that it is held out of court. It is in principle initiated by 2 steps. First, by signing an agreement with a selected restructuring advisor who acts as the supervisor of the arrangement, followed by an announcement in a public register of what's called the arrangement day. The arrangement day serves as a cut-off date, separating the liabilities covered by the arrangement and subject to restructuring that have arisen before this date from the liabilities that arise after this date, which the debtor must settle on an ongoing basis. Following the announcement of the arrangement day, the arrangement supervisor presents the proposal of the arrangement to creditors and collects their votes. Voting is on a ballot forms sent via specially dedicated platform called the National Register of Debtors. The supervisor provides the debtor with professional support throughout the procedure, including by preparing a restructuring plan and table of claims, as well as an opinion on the feasibility of the arrangement. Once the arrangement has been approved, the same person supervises the debtor's implementation of the arrangement. The arrangement approval procedure lasts a maximum of 4 months from the announcement of the arrangement day. During this time, the debtor and the supervisor must convince the creditor to vote in favor of the arrangement, and once it has been voted through, apply to court for the arrangement to be approved. During the procedure, the debtor gains protection against enforcement actions taken by creditors. Also, key contracts that the debtor enters into may not be terminated, as long as the arrears under them have arisen before the arrangement day. On the other hand, the debtor's management of its assets is restricted by the consent of the supervisor that is required for actions which exceed the scope of ordinary management. An arrangement approval procedure may be conducted only if disputed claims having an entitlement to vote on the arrangement do not exceed in total 15% of the sum of all claims. The procedure should be launched as soon as a threat of insolvency arises for the entrepreneur, which in a short while may lead to actual insolvency. It is also possible within an arrangement approval procedure to enter into a partial arrangement that would cover only some of the debtor's obligation, such as to financial creditors or suppliers. An arrangement may involve various forms of restructuring, such as reduction of liabilities, spreading them into installments, postponing their repayments, as well as the conversion of debt into shares. The court stage of the procedure begins with the submission of an application for approval of the arrangement. The court's role is limited to checking the legality of the accepted arrangement, and if the verification is successful, formally approving it. It normally takes several weeks for a court to approve an arrangement. Creditors might challenge a court order that has approved an arrangement, which may significantly delay the start of its implementation. Once an arrangement has been validly approved, the debtor proceeds to implement it, usually by repaying the creditors in accordance with the terms of the arrangement. Statistics show that the arrangement approval procedure accounts for approximately 85% of all restructuring procedures chosen by debtors. Its main advantages are its speed and the close cooperation between the debtor and the arrangement supervisor, who provides the entrepreneur with comprehensive support during the restructuring. My experience of conducting an arrangement approval procedure is that it is an effective tool for restructuring debt, as long as initiated at an early stage of debtor's insolvency and in consultation with creditors.
The war in Ukraine has mobilized Poland and other European countries to rapidly purchase armaments and to invest in the arms industry. The Polish government, with the support of the European Union, has contracted Polish factories to produce huge quantities of artillery ammunition. This is to replenish ammunition stocks in Poland and other NATO countries, after significant quantities were transferred to Ukraine. These orders will provide ammunition manufacturers stability for many years to come. Poland has purchased American tanks and air defense systems. From South Korea, our country has ordered tanks, howitzers, long-range missiles and light combat aircrafts. Polish shipyards have been awarded contracts to build a new generation of multi-purpose frigates. This equipment will have to be serviced, rearmed and upgraded in Poland over time. Some types of foreign armaments will be partly manufactured in Poland. In the long term, it should boost development of the Polish defense industry and sectors of the economy associated with it. Thank you for watching this episode. See you next time.